Good morning. Uh, See, to answer All India Bar examinations, you must go through the uh, index index of the particular act, Code of Criminal Procedure Code. See this chapter 1 to uh, chapter 37 up to 37. So chapter wise you also understand. The chapter 1 deals with preliminary. Like that, so many things are there, I will come later. Now today the judgment which I am going to discuss with you is about framing of charge. The framing of charge 211, this is chapter 70. How to frame the charges are 2000, section 211 to 224 is described. So you have to go through that, how charges to be framed. If any lapses are there, then you can challenge it by revision if the charges are framed. And if you certain things are totally absent to frame the charge itself, like absence of time, place, the person, and then you can very well file quash proceedings. Then question of framing of charge under warrant trial cases and sessions court is important. Keep in mind that even in trial before a court of sessions chapter 18 and chapter 19 trial before the magistrate court commences from the provision to discharge, not from framing charge. First they have to apply mind whether there is any material to frame charge. If there is no material, you have to discharge. That is the first provision. Then question arises, framing of charge. Here three things are there. 226, 227, 228 and 229. And for court of sessions, framing of charge 228, 229 conviction and plea of the guilty, 227 discharge. Here also sessions court also the section says 229 discharge, 240 framing of charge, 241 conviction on plea of guilty. If plea not guilty, then it goes to trial. Now I will take you the judgment, because if anybody wants to question the framing of charge, this judgment would help you, because multi number of Supreme Court judgments were discussed, but some ratio has been given. AR 2022 Supreme Court 54-54, AR 2022 Supreme Court 54-54. The lower court framing the charge, when final report was filed under section 302 IPC, the court only framed charge under section 304 part 2 IPC. So the Supreme Court says, they say all that is required at this stage is that the court must be satisfied that the evidence collected by the prosecution is sufficient to presume that the accused has committed an offence. That apart, they say even a strong suspicion would suffice. Therefore, they have set aside this. You go through the facts and other cases. It will be very interesting to read the judgment if you want to clearly understand how to challenge the framing of charge. Multi number of cases were discussed. Best wishes.